Mr. Presiding Officer, Mr. Pro Leader, my colleagues, good morning. I present you with my privileged speech entitled Honoring Justice and Legal Integrity, the Federal Law Engagement Explained. Mr. Presiding Officer, distinguished colleagues, I rise today on a matter of personal and collective privilege to clarify the truth behind the engagement of the Salazar and Enrique Defensor and De Mata law offices Senado, and the 25% contingent fee associated with their successful handling of the writ of Kalikasan case, which led to the $100 million settlement agreement between the provincial government of Marinduque and Barrick Gold Corporation. This representation speaks not to defend individuals, but to uphold the integrity of due process, public accountability, and the justice long sought by our people. 7 puntos po ang aking nais linawin. Number 1, SEDA law's engagement was lawful and proper. Ito po ay ayon sa batas at nasa ayos ang ating engagement with SEDA law. The engagement of SEDA law was authorized, transparent, and COA approved, Mr. Chair. It was based on the Sangguniang Panlalawigan resolutions numbers 688, 716, 1064, and 823 series of 2020 to 2023, which empowered the governor to hire specialized external counsel for the writ of Kalikasan case. The Commission on Audit, through its legal retainer reviews numbers 2021-168 and 2022-043, expressly approved this engagement, recognizing the extraordinary legal and technical nature of the case. Hindi po ito pangkaraniwang kaso laang, at yan po ay kinilala ng COA. Thus, Senalo's hiring was not arbitrary nor irregular. It was carried out under the authority of the Sangguniang Panlalawigan in full compliance with the Public Act 9184 and with COA oversight. Every step was guided by legality, necessity, and prudence. Number 2, the 25% contingent fee is lawful and reasonable. Contingent po, may condition. Ito po ay ayon sa batas, tama lang. The 25% contingent fee has been questioned by the governor in many a public forum, but it is well within the legal and ethical bounds. In Francisco Rayos versus Attorney Ponciano Hernandez, GR number 169079, August 28, 2007, the Supreme Court upheld a 35% contingent fee as valid, stressing that such arrangements are not improper and often enable litigants to pursue justice they could otherwise not afford. The SEDA law fee, Mr. Chair, is performance-based. No win, no fee. Yan po yung contingent nga nila, yan po yung condition. No win, no fee. It is self-liquidating, paid only for the settlement funds, not from public funds or the province's national tax allotment. Kaya po pong inasabi na ito po ay akunin sa ating ira o nata na maapektuhan ang budget ng ating probinsya at kaya hindi makakasweldo o hindi kakapag-function bilang administrasyon o provincial government. Hindi po totoo yun. Ladies and gentlemen, my colleagues, SEDA law took the risk, and Marinduque reaped the reward. The province did not spend a single centavo before victory was achieved. Victory was achieved with SEDA law, and now, will we hold back on our commitment? We must remember, Mr. Chair, that the American lawyer hired by the provincial government in the case filed in Nevada, USA, the approved contingent fee was up to 40% for recovery of more than $15 million. Likewise, a Canadian law firm, Trudell, Johnston, and Lestrans proposed for another case legal fee of 25%, but not full contingency arrangement. Thus, the province will also need to enter into another contract with a third-party funder, makakasok pa po sa third party, which will be added to the cost to the province. Madagdag pa po dun, bukod po sa 25% ng non-contingent arrangement, madagdag pa po yung sa funder. With this, Mr. Chair, we can say that the 25% legal fee plus expense of a contingency arranged with SEDA is reasonable. Pangatlo po, no public funds are involved. Hindi po ito mula sa kaban ng bayan. Under the Provincial Ordinance Number 250, Series of 2025, all settlement proceeds are placed in a trust fund, a special account created solely for local disbursement related to the settlement agreement. The contingent fee will be drawn exclusively for this fund, subject to accounting and auditing rules. Hence, Mr. Chair, no taxpayer money or regular government allocation is affected. Pang-apat po, a matter of precedent and consistency. Ito po ay may pinagsundan na. This is not the first time our province engaged council under a contingent fee arrangement. In Resolution Number 264, Series of 2005, the 10 Sangguniang Panlalawigan authorized then Governor Clemencita O. Reyes to hire attorney Walter Scott for the Placer Dome case under a higher tiered contingent fee. The SEDA law arrangement, by comparison, is more reasonable and transparent, consistent with long-standing legal practice and the province's historical approach to international litigation. 5. On the DILG opinion number 82, series of 2005, claims that SEDA law's hiring is legal under DILG opinion number 82, series of 2025 is misplaced. The opinion refers to municipalities hiring private lawyers as consultants without authorization. It is not to provincial governments engaging specialized counsel for complex international cases. Our case, SEDA law's engagement, was properly authorized by the Sangguniang Panlalawigan and procured under Republic Act 9184. Therefore, the DILG opinion does not apply and cannot invalidate the contract. Hindi po ito pinuri sa atin. Number 6, on the use of settlement fund. Some have also claimed that the settlement fund is limited solely to rehabilitation. Again, Mr. Chair, this is incorrect. Under Section 5.1 of the settlement agreement, all funds received by the provincial government of Marinduque shall be used for local purposes and for the benefit of the provincial government of Marinduque, subject to proper accounting and auditing in accordance with applicable laws. This means rehabilitation is a priority, but it is not the exclusive purpose. The fund may also cover other lawful uses, including obligations arising from the case, provided all disbursements are transparent, audited, and beneficial to the province. Malino po yun. Finally, number 7, a call for fairness and perspective. Mr. Chair, kita po ay lumagay sa patas yung ating pananaw, ilagay natin sa tama. Mr. Presiding Officer, after nearly 3 decades of litigation, SEDA law delivered what many thought impossible. A $100 million settlement, the largest environmental recovery in the history of Marinduque. To question their legality now is to question the very process that gave Marinduque justice. Their work, that of MASIC, and their work, the SEDA law, was not only legal, it was transformational, turning decades of frustration into a tangible victory for our people. The SEDA law issue, therefore, is not about fees or personalities. It is about respect for law, for due process, and for the success achieved through integrity. Mr. Presiding Officer, my esteemed colleagues, the SEDA law engagement is a story of lawful action, rightful reward, and earned justice. The 25% fee is not a burden on our people. It is a rightful acknowledgement of our victory, long denied, but finally delivered. Ang hustisya na ating inamithi ng napakalaang panahon, halos 3 dekada, ay nariyan na. Maski papaano, may naganap na. Now, Mr. Chair, my colleagues, let us honor justice, not with suspicion, but with fairness. For justice achieved through law inherently possesses integrity that demands preservation. Thank you, Mr. Chair. Mr. Presiding Officer, thank you, my colleagues.